is a schedule. I'll have to take my
Okay.
parents, my lord.
Okay, we'll have it after 2 weeks at the request of Mr. P. Sharma, the Learned Standing Council of the Railway. Matters can be done to be discussed after 2 weeks.
My lord, I take item 21.
Hmm.
As per my information, matter has been instructed.
What is this information business? You are instructed
Yes, I am instructed before.
to inform this court. Mr. M. H. Rajbhurmi, the Learned Counsel appearing on behalf of the petitioner, submits that the instant writ petition has become infructuous, and as such, he would not like to further proceed with the instant proceed. So, taking into account the said submission, the instant writ petition stands closed as it has become infructuous. Interim orders, if any, stands vacated. Hmm.
I got item number 32 and 33. I was supposed to file my reply affidavit, but I took outside my 2 weeks time.
Mr. A. H. M. R. Chaudhary, the Learned Counsel appearing on behalf of the petitioner, seeks an accommodation of for filing the reply to the affidavit in opposition to file, taking into account above is the matter of 4 weeks. No. So difficult to get the matter listed and you have not done it.
Obligement. Item number 15.
Yes.
1 week's time. File reply in affidavit.
What affidavit?
Reply in affidavit.
Why?
The government has claimed that they have all the amount of the paid, but they paid the
When did they file the affidavit in opposition? When did they file the affidavit in opposition?
The government filed the affidavit in opposition. They
When?
explained the
When?
2018 lot.
And now you are in 2024 asking for time.
Petitioner is residing with her daughter in Bangalore.
So it takes 6 years.
He is not double. 1 week.
1 week, cost of 50,000. You are Mr. N. Ahmed, the Learned Counsel appearing on behalf of the petitioner, seeks for an accommodation for filing the reply. It is taken note of that the affidavit in opposition was filed in the year 2018. Taking into account for the interest of justice, 1 week time is granted for filing the reply, subject to deposit of a cost of rupees without
purchase,
No.
her husband is
cost of rupees 3,000 to be deposited before the registry of this court at the time of filing of the affidavit in reply. It's the matter again on 5th of February 2024.
May I please, Lord? My lord, additional affidavit filed in item number 30 to the amount that may be public.
I get to mention item number 4. Can I be allowed to proceed?
Your name?
Yes, Abba.
Mr. S. Alam, the Learned Counsel appearing on behalf of the petitioner, submits that he has instructions to withdraw the instant writ petition. Accordingly, the instant writ petition stands closed on withdrawal. Interim orders, if any, stands vacated. Yes, Mr. Jaidas.
Item number 22, your lordship.
Yes.
It is a tender matter, your lordship. It has become infructuous.
Tender matter.
The lordship, in the year 2018, it was for a period of 12 months. What is matter? It has become infructuous.
Mr. Jaidas, the Learned Counsel appearing on behalf of the petitioner, submits that the instant writ petition has become infructuous, taking into account that the tender was for a period of 12 months. So taking into account the above, the instant writ petition therefore stands dismissed on withdrawal. Interim orders, if any, stands vacated. Huh?
Item number 2. On behalf of
No. Steps we'll see. Why? Next.
I wish to mention item number 45, my lord.
Yeah.
But matter become infected. Tender matter for 1 year.
Huh?
Tender matter
Yes,
for 1 year matter already infected.
Mr.
ठीक हो गया ठीक हो
On behalf of
Right.
the learned counsel appearing on behalf of the petitioner submits that the instant writ petition was filed challenging a tender proceeding. The said tender proceeding in the meantime had elapsed. Under such circumstances, it is the submission of the learned counsel to the petitioner that the writ petition has become infructuous. Taking into account the above, the instant writ petition therefore stands dismissed on withdrawal. Interim orders, if any, stands vacated.
My lord, I have got a writ petitioner here.
Hmm.
In this case, my lord, the petitioner has lost contact, my lord. I think
Very well.
probably he's not interested, maybe, I don't know. So that is why I'm submitting, my lord, because I have no instruction. And he has not engaged somebody else. Also.
What is this matter about?
Lordship, they have come against an order.
Petitioner, who is it?
Lordship, I'm
Yeah.
sorry.
Yes, what is the matter about, Mr. Kotoki?
My lord,
What is the matter about?
my lord, this is, we have come against an order passed by the recovery officer of the debt recovery tribunal, my lord.
Hmm.
We are selling this order of attachment 27/2018, my
Hmm.
passed by the court. So against this-
27, 2018, order of attachment. Let us see what is wrong with the order.
actually, my lord, this order actually we filed it against because our case was that it was arbitrary, illegal, and all that, my lord, without and against and also that it
Yeah.
was passed by against by wrongly mentioning the name of the act. my lord. Actually, my lord, I was taken from me, so I do not know much. I've lost contact.
Against this, an appeal lies
Section 30. Section 30
of
of Recovery of Debts and Bankruptcy Act.
section 30.
30 will, that is after the attachment.
30.
No. Any order passed by the Recovery Act. May I read?
30.
30.
30.
May I read? It's very specific about.
The instant writ petition has been filed by the petitioner challenging the order dated 27, 2018, passed by the recovery officer number 2, Debt Recovery Tribunal, Guwahati, whereby
Order of attachment.
To the recovery.
the mortgage properties which were described in the recovery certificate were attached. This court have also taken note of that an appeal lies against the said order under section 30 of the Recovery of
Debts and Bankruptcy Act 1993.
1990 as amended up to date. Further to that, this court does not find any jurisdictional error committed by the recovery officer, Debt Recovery Tribunal, in passing the impugned order dated 27, 2018. Consequently, the question of issuance of a writ in the nature of certiorari does not arise. Accordingly, this court finding no merit in the instant writ petition, the writ petition stands dismissed. The interim order, if so passed, stands vacated.
Madam, can one line may be recorded that I have not been given any instruction. But
No instruction, what is to be done out there? That is your lookout. If the IA stands disposed in view of the IA, the interlocutor, IA stands disposed in view of the dismissal of the writ petition. Stands dismissed also. And the interlocutory application stands disposed in terms with the judgment, in terms with the order passed in the accompanying writ petition. Yes, you have taken time, you have taken steps. Huh?
I continue on the on.
Who
on
is
the-
your senior?
Mr. Ekut.
Huh?
Mr. Ekut,
A. A. Purkaskar. Where is he?
on his way.
Steps upon whom? No steps have been taken.
Lordship, continue instructed me to take a step.
What is the matter about? Let us see.
Matter like no confidence.
Into. I think that's special. Yes. PNRD, what do you have to say? What is wrong with the order? Resolution? You are challenging some resolution.
No confidence motion matter.
Why?
It is a gross violation of the provision.
Huh?
We are alleging that it is in gross violation of the provision to be Assam Tax Act.
Section 15?
Yes, ma'am.
Why? We are not getting the help from the petitioner. Let us get the help from the PNR.
Even I actually take the battle for no step violation. I have actually gone to detail.
First of all, you filing a repetition of 93 paragraph makes it very clear that this you don't have a case. And then you don't take steps.
Lordship, we have taken a step as per my
No
instruction.
steps. On the last occasion also, when the matter came up before this court, I granted you 7 days time to take steps. Then
Lordship,
also you have not.
today take
When?
today already advocate and trusted for the
Where is your senior?
on his way.
Okay, we impose a cost of 15,000 for not taking steps. Then only the matter would be again listed. Hmm.
He already
So you have not taken steps as per the court's order. I have guaranteed you 7 days time, you have not taken steps. This court perused the office note dated 11/1/2024, as well as the orders of the Lozima Court dated 7/9/2023, and the order passed by this court on 20/12/2023. From the above, it reveals that the petitioner had not taken steps against the respondent numbers 7, 8, and 10, despite there being a direction to take such steps. Consequently, this court, for the interest of justice, grants an additional opportunity of 7 days to the petitioner to take steps subject to the deposit of a cost of rupees 5,000 to be deposited before the registry of this court at the time of submission, at the time of taking steps. List the matter again on 29th of January 2024.
May it-
Hmm.
In this matter, we will to take step by justice on response number 5, but not there is some difficulty with communicating with the client.
Huh?
Yes, but some difficulty there in communicating with the client.
What steps? Why haven't you taken steps upon respondent number 5?
So, Lord, 1 week time, maybe then we take the
What is this matter?
step with the insurance.
You have not taken steps upon the respond number 5. Hmm? Despite the court's order, the petitioner has not taken any fresh steps for service upon notice upon laid the matter before the court for favor of Imat. Then you want 7 days time, subject to a deposit of 5,000, 10,000. This court, the record reveals that in spite of various orders being passed by this court, steps have not been taken upon the respondent number 5. The learned counsel for the petitioner seeks for an additional opportunity to take steps. Full stop. This court, in the interest of justice, grants an additional 7 days time to the petitioner to take steps upon the respondent number 5, subject to a deposit of a cost of rupees 5,000 to be deposited before the registry of this court, along with the steps. List the matter again on 29th of January 2024.
There's an interim order.
The interim order so passed shall continue till the next day.
Item number 2, my lord, I have taken step today.
So you were supposed to take steps. Now you have come. So your junior was there. So I imposed cost of no. Your junior was there, so I have imposed the cost of 5,000. Now you have come. I'll make it 10,000. 10,000 negative.
Appreciate.
10,000.
Today I have taken steps.
Absolutely no, Mister. You have not taken steps in spite of various orders being passed by this court. Sorry.
I have
Go and
taken
file
this
an
step.
appeal.
I have taken this steps, my lord, step returned or my lord, answered. Then I was directed, my lord, that was a wrong order.
There was a direction passed on the last occasion on 2012-2023 for taking steps. You have not taken
My
steps.
lord, I had to contact my client, my lord, to get the.
That is your lookout. If you are not in
Kindly
a
appreciate
position,
that today still I have taken steps. my lord.
I am not. Deposit another 5,000 and you want, I can increase it to 10,000.
My lord, okay, I think, my lord, it is not equitable, my lord. Because there is a lapse on my part, but today itself, my lord, I have-
Okay, the cost shall be not being borne by, the cost shall be borne by the council then.
my lord, lordship, I appreciate, kindly appreciate.
Sorry, no.
Then lordship will reduce the, my lord, amount.
I have made it 5,000
I'm
because
sorry,
it
my
was
lord.
your junior. Now you have come, I'll make it 10,000.
I'm sorry, extremely sorry. This is not the, my lord, lordship, you have to appreciate. my lord.
Sorry,
What is the
Mr.
problem with us?
Mr. Purka is so sorry. Can't help it.
I'm
You file
extremely
an
sorry, my
appeal.
lord. This is not the way, my lord. I have long practice, my lord, 40 years of practice.
Sorry.
When I made a statement before the court is to consider my statement.
No, absolutely no. When there was a specific direction, first time I never do it. But when it is the second time, obviously a cost has to be imposed. Otherwise, it is not,
At the same time,
it becomes a behavior out there.
my lord,
sorry.
is to appreciate what is the problem with the advocate. Sometimes
Problem with the
we
advocate,
have-
does it take for a long time for you to take steps? And this is not the first time. The order was passed in Lozima Court's order was passed on 7/9/2023.
Lord,
Thereupon, the matter came up before this court on 2012. At the assurance given by your learned counsel, who had appeared out there that he is going to take steps within 7 days, the matter had no steps was taken. And you want to take you are saying that you have taken the steps today.
There was a long, my lord, long holiday.
So
Long holidays, how can I, my lord? And their court was.
long holidays was okay. Therefore, today the matter has come. We are on the 19th.
This is not the way, my lord. I am sorry, my lord.
Sorry,
my lord. This
I
is
can't
not
help you.
factor for me to deposit 5,000.
You
The
deposit.
Question is, my lord, I have taken steps. Lordship has to appreciate that fact.
I won't.
I'm sorry, my lord.
I can't help.
It's not the way.
Yes. Who is appearing? Nani appears on behalf of the petitioner on call. The record reveals that the petitioner had not taken, yes, why haven't you taken steps?
You already taken step yesterday.
Huh?
We have taken step
When?
yesterday.
The learned counsel appearing on behalf of the petitioner submits that he has already taken steps upon the respondent number 7 on yesterday, 18.
18.
On 18/1/2024, taking into account the above, list the matter again after completion of service upon the respondent number 7. Yes, who is appearing? Yes, who is appearing for the government? Yes, madam.
My lord, we have received instruction, madam. We have read it. Read it.
Mr. Mohanto, what is this case about?
My lord, the time for the respondent number 8, 7, and 8 and 9.
Hmm.
Petitioner, my lord, they file a application for my lord, their total 4 kathas of land and 2 kathas of 10 lesser land that was allotted to my lord respondent number 8 and 9. And now, my lord, he is paying for the rest of the land, my lord. It will be, my lord, allotted to him, my lord, because he is in the land is not yet to be allotted. He says that, my lord, because of the obstruction given by the path is obstructed, my lord, that's why he's not been getting any result from the government.
His case is, if I'm not wrong, on the backside
Yes.
is his land.
Now
he wants the
backside, backside his land, but his land is yet to be
Understood, but that has not been settled.
that has not been settled.
Now the front portion has
For
been settled to
settlement,
8 and
my
9.
lord, we have already premium has been deposited. Now, similarly, she also wanted.
But I've asked them to find out as to whether the periodic patta or the AR has been issued
No,
in the name of
periodic
the.
patta is now is converted to, my lord, Sarkari land by Revenue Board
Yeah,
order.
that is okay.
Now, my lord, another that his application for, my lord, application for consideration that has been pending, and they were asked to take instruction that what happened to that matter.
It was 22/11.
But
Ah.
take it out.
Without that, it's smaller time. Out of
Take a look at it. Right.
Madam, I think this instruction which you are placing
My
needs to be placed by way of an affidavit.
lordship,
Because what has happened, this has a serious connotation as regards the petitioner is concerned.
lordship,
You say out here that the petitioner did not apply as per the 89 Act, as also by the land policy of 2019.
19.
You also say that the petitioner is not in possession of the land in question.
Lordship.
So I think these instructions be put by way of an affidavit so
Lordship.
that they can file a rebuttal.
My lord, lordship.
Pursuant to the directions passed by this court on 21/11/2023, Ms. Yudas, the learned additional senior government advocate, has placed certain instructions issued by the additional district commissioner, Kamrup Metro. Taking into account the contents of the said instructions, this court is of the opinion that the same should be put by way of an affidavit so that the petitioner is in a position to rebut to the same, if so advised. Taking in that view of the matter, list the matter again on 7th of February 2024. The district commissioner, Kamrup Metro, or his delegate is directed to file an affidavit on or before 5th of February 2024.
Okay.
But you have not been issued the patta. You have not been issued the patta.
Yes, madam.
You are still in the stage of 16, Rule 16. Only a permission to be allowed.
But my
Premium is
been accepted,
immaterial.
madam. Long back, my lord.
Maybe you have given the premium in 2006, but that doesn't mean that you have any right over the land except to be in
Because of
possession.
His complaint, my lord, because of her complaint, my lord, my paper was not been issued, my lord. The process is already in the final stage, my lord.
Understood, but you have not been issued the patta. You don't have a right over the land.
But already
Yeah.
premium has been
You have
accepted,
only
my
a right to remain in possession, but you don't have a right over the land. Is the difference?
lord. It is already been, my lord, accepted by my land advisory committee, passed my order, and I
Whatever may be, but we are to go as per the Assam Land and Revenue Regulation.
Right.
Assam Land and Revenue Regulation categorically mentions that it is only in respect to issue or pursuant to issuance of a patta.
Right.
And you see that there is a difference out there. I have dealt with one judgment out here, Kachar Transport Association.
Right.
You may have a look at it. That in that judgment, I have dealt with this aspect as to, you see, this is a case of a recommendation
Right.
by the governor. The governor had not settled it. It's only a recommendation. So the recommendation which is there, normally in many cases you will find the governor having settled it. But here, if the governor settles it, then you come in, bring in settlement rule number 1, and you can very well issue a file a writ directing the deputy commissioner for issuance of a patta. You have a look at that judgment.
Yes, sir.
So there is that aspect I have also mentioned, that a right is conferred on the basis of a settlement being granted. As of now, you have been recommended for settlement. Kindly appreciate. If it is a settlement being granted, it's a question becomes different. Once a settlement is granted, the settlement is regulated by the patta. But as of now, nothing is happening. Your 15 lakhs have been taken, but they have not done anything. I think it's high time you need to advise your client properly.
Sometime.
You ask Mr. Borpujari, he has the
I also have the
No,
copy.
yeah,
Oh, you have it,
My
give it to him.
lordship.
Because that is a very important aspect.
Right.
Yes, ma'am.
May I please the lordship, lordship the petitioner has filed a due petition. The case has not been listed yet, but
Huh?
the petitioner has filed a due petition. If the case has not come up yet, not been listed, if the matter
After 3 weeks. Is this matter shown as part heard? The learned counsel appearing on behalf of the petitioner submits that and fresh petition has been filed. Be that as it may, this court does not further is of the opinion that the requirement of keeping the matter part heard would not serve would not be in the interest of justice. Accordingly, release from part heard to be listed as and when the registry deems fit.
All probably this particular petition has become infructuous. There are some 5 or 6 petitioners.
What is this
Well, all
all
Monday.
probability? What is this petition?
From the
No, first let us see it. So many petitioners.
5.
Why?
Regarding my lord, prayer for rewomen of the goods, my lord, if they are found to be, my lord, overloaded in the destination station. We used to submit petition before the authority that they should be reweight in the destination station. If it is found to be, my lord, overloaded before imposing any penalty, interim protection was given, my lord. I don't think so, my lord. Now in 23, this particular petition.
No, now they have a way bridge. Earlier, your problem which was there at that point of time.
It was in Maharashtra.
Yes.
In our case.
No, you had to send it long I think,
Bongaigaon, my lord.
huh?
Back to Bongaigaon, my lord.
Bongaigaon. Now you have a way bridge, so nothing
Now,
remains
the
out there.
destination, yeah.
This is in terms with 74, I
Yes.
suppose.
On
The
Monday,
learn-
my lord,
The learned counsel appearing on behalf of the petitioner. I have heard this court have duly heard the learned counsels appearing on behalf of the parties. Full stop. It has been submitted at the bar that at present there is a way bridge
In motion way bridge.
at
Electronic in motion way bridge.
electronic in motion
motion
way
way
bridge at
Guwahati. New Guwahati.
New Guwahati. And as such, the difficulties which were arising at that relevant point of time when the writ petition was filed no longer exist for weighment, for reweighment of the goods in question, of the rack in question, no?
No, my lord, they're different, my lord. Sometimes the parcel vans come, sometimes truckloads. The whole
Rack,
Rack
no.
is the whole trade.
Wagon.
This is
with the wagons in question.
Right.
So taking into account the above, the instant writ petition stands closed as it has become infructuous. Interim orders, if any, stands vacate.
Liberty, my lord, that if at all.
That is already there. That is why do you need a liberty?
Tomorrow, if they don't, my lord, agree with the rewomen, that case.
Isn't that a separate cause of action?
My name may be reflected.
I can't. You put your name properly in a paper and give it to these people. Yeah. Yes, what is this? Mr. B.N. Gogoi? Yes, come here now. This matter. What is it? HTC Logistics? Same. Same. HTC Logistics.
It will be same.
Same.
Issue regarding rewomen.
Lordship,
You are appearing here, Mr. Gogoi?
Lordship, one judgment has already passed by Binayak Logistics that matter.
No, it's okay, but now they have. So,
Not
same,
the interim protection.
same
as
order.
well as
same order. This post. Interim.
Lordship, may kindly see the last order. By that order, the health department was directed to deposit the, my lord, rent
yeah.
acquisition
Hmm.
by today.
Hmm.
My lord, I pray, my lord, by today or by tomorrow, the check will be deposited before the, my lord, the deputy commissioner by the DME, that may be recorded, my lord. Only 1 day's time we require, it will be deposited, taken, collected thereof.
Okay.
Since it is a specifically
Release the
mentioned in
matter again on 22nd of January 2024, on which date Mr. B. Gogoi,
Yes,
the
sir.
learned counsel, appearing on behalf of the health department, shall apprise this court as to whether the amount
9,91
so directed by the order dated 10/1/2024 has been deposited by the health department to the district commissioner, Kamrup Metro.
You can put it 23rd
Why?
here for the day.
No,
No.
there's no holiday.
Okay.
Okay.
11. Praying for typing.
Why? That day, that matter, why were you not there when the matter was taken up? That remember that matter? pertaining to that oil, what do you call that? Granting of AR on this corporate, what is that name? Corporate purpose fund. Why were you not there when the matter was called up? There were no court sitting at that point of time.
Records were with me.
Yeah.
For time.
Why? What is this? What are you asking for?
That is declining of grant of tea plantation.
At the revised 12 plan rates for replantation activity undertaken by AIA in each state between so and so and after the new rates came into force. Who has declined? The tea board.
By the
Who is paying for the tea board?
Yes, Lordship. I'm appealing for the
Yes, what is your instruction?
Lordship. My senior has received instruction, but he is not there.
Very well. These are the matters of 2016. Does it look nice that you are not prepared? After being here for 2 years out here, you must be knowing that this court doesn't grant an accommodation on the ground of senior. Are you aware or not? Or you are new? You joined only 2 years, within these 2 years. Then Chalo. As the council appearing on behalf of both the parties are not ready with the matter, to list the matter again after after 4 weeks.
Deeply obliged.
Yes,
This matter is regarding my lord, the it is still my lord unit of the petitioner was my lord.
Huh?
Inspected by the my lord, the authority my lord. Right, that's the premises my lord.
what
my
has
lord-
happened? What are you asking for?
My lord, and my lord, thereafter my lord, a my lord bill was raised my lord.
Now, what is your case about?
Now my lord, what happened my lord, that bill, after that bill was raised my lord, I preferred an appeal my lord as per 127 of the act my lord.
Very well,
And my lord, what happened, they have my lord reduced the bill my lord.
very well.
My lord, we have paid my lord, and my lord, the
So the matter has become infructuous.
no, my lord, no, my lord,
The appeal has already decided, then what remains?
my lord, decided my lord, and I have paid my lord.
So-
Paid their one part, my lord, after 2 years, my lord, more than 28 months, my lord, they raised another bill, my lord, that their audit department has raised objection. So, my lord, I have to pay another 2 lakhs, more than 2 lakhs, my lord. And my lord, also a disconnection notice was also issued, my lord. Against that order, my lord, I have came before this honorable court, my lord. The honorable court.
No. Tell me, there was initially a proceedings
Yes, my lord.
under, there must have been a inspection being made.
Made, my lord.
126, there must have been some assessment being done, provisional assessment, final attest.
My lord.
Against that, you preferred an appeal under 127.
Right.
Now, the appeal was partly allowed.
Right.
And thereby, it was changed.
Right.
And accordingly, you made the payment.
Payment.
Then now APDCL authorities are going against the order of the appellate authority.
Actually, after 58 months.
Yes.
And my lord, the criminal case also my lord.
Forget about criminal
That
now.
order was also there.
My instructions, my lord, still, these are only oral instructions. If my lord took directs my get them in writing. Petitioners has finally approached the PDCL authority seeking to pay the entire.
Huh?
The petitioner has approached the PDCL authorities seeking to pay the enhanced amount.
This amount of 2,87,000.
2,87,000.
Then
Nothing would probably remain, my lord. So I'll get that instruction.
no, when the appellate authority has passed an order,
My lord.
Can there be anything else which has been mentioned? Unless you challenge that order of the
Yes, my
appellate
lord.
authority? Reference to in respect to the authority objection as per instruction of the commercial year assessment bill for the period of year was revised. But view of the letter, I would like to say that the bill has been served as per the verdict of the appellate subsidiary of Electricity Act. And the further the bill cannot be tried to withdrawn from this exercise. Yes, how is it possible?
Well, I'll come back with the instructions, my lord.
It's a
If
very
they've act-
serious issue. Then, if this be the issue, then we should also hold that the authorities are not bound under 127. So all the appellate authority, the non-exercising of writ jurisdiction under Article 226 by this court on the ground of 127 should not be made.
I'll just come back with the instructions.
Okay, 22nd.
Right.
Mr. P. Chaudhary, the learned counsel appearing on behalf of the petition respondent APDCL, submits that he would like to take instructions in the instant matter. First, list the matter again on 24th of January 2024.
I'm deeply.
Hmm.
In this case, Lordship, the PDS license of the petitioner has been cancelled, Lordship.
Huh?
PDS license.
PDS license, what has happened to your license? They've
was
cancelled it.
Lordship. Next time, 4 page 23, Lordship. The
Shall not be issued to set aside and quash the impugn order passed by Iman and also Iman and forfeit recall and passed by the director. What happened? Where's your license?
license is annexed.
What is the order? Seen the reply dated so and so. In reply to the so called reply, the reply is found that the reply in the it can then this happened in 2017.
Lord.
Then
We have challenged this order also on the ground that we have not been given proper opportunity of hearing first while cancelling this license.
what additional opportunity you want?
So, my Lord,
You want the appearance of a lawyer?
so, my Lord,
Then
I have
you were
submitted-
given a show cause notice, you have submitted a reply. Then I think does the clause 15
15
say
Lord,
anything else?
15
Only a show cause.
but, my Lord, 15 says that no cancellation of that shall be passed
Without.
without giving him an opportunity or either be stating his case. Lord.
So you have submitted your reply.
There is another line that to the proposed cancellation. Here, Lord, in this order, there is no proposal was made for cancellation. Directly cancel the license. Lord.
No, you have issued the notice.
The notice is annexed to Lordship, page 70.
Yes, what do you have to say?
Lordship, on 20, that page 17, Lordship, that Stoker's notice, he was Stoker's, opportunity was given to him, but in the reply, only he has addressed the closing part. Remaining part, he has not addressed, Lordship.
What
According
remaining?
that Lordship may kindly page 17, Lordship,
Hmm.
second paragraph, it is hereby informed that during inspection by the deputy
There was no display board showing in the
Yes,
present
yes.
stock. When the shop is closed, obviously, how can there be a display board? Do you expect that there will be a display board in front of a closed shop? My goodness. Is it? Is it the mandate of the clauses that in front of a closed shop you should have a display board? If it is so, it's very well.
But he has admitted that the shop was closed, Lord.
Okay, you issue him a show cause notice properly. I set aside, but that will remain suspended.
To take a fresh decision.
You take a fresh decision by issuing him a proper show cause notice, and his suspension of his license, the license will be remain suspended for a period of 90 days. So you complete the process within that period.
Good.
I think that is the instant writ petition has been filed by the petitioner being aggrieved by the order dated 17/3/2017, passed by the Deputy Director cum Issuing Authority, Food and Civil Supplies and Consumer Affairs, Sipsagar, whereby the license of the petitioner was cancelled full stop. The facts as is could be seen from a perusal of the writ petition is that the petitioner herein was issued a license under the provisions of the Assam Public Distribution of Articles Order 1982, for short, the order. Full stop. The said license was renewed from time to time, as would be apparent from a perusal of Annexure 1 to the writ petition. Be that as it may, on 18/2/2017, at 10:30 a.m., the Deputy Commissioner, Sipsagar, had made an inspection and found the shop of the petitioner to be closed. And there was also no display board showing the present stock. Under such circumstances, a notice was issued on 23/2/2017 asking the petitioner to show cause for the violation mentioned in the said notice and to submit a reply within 3 days before the Deputy Director cum Issuing Authority, Food, Civil Supplies and Consumer Affairs, Sipsagar, failing which legal action would be taken. The petitioner, on receipt of the said show cause notice, submitted a reply on date, submitted a reply
On 27th, Lord.
on 27/2/2017, stating inter alia that he had to go to Demo Hospital on that date when the inspection was carried out for the treatment of his wife, for which the shop was kept closed. He further stated that he had submitted the register in the office and the incident occurred due to the illness of his wife. The record further reveals that to the said reply, the petitioner also had submitted the medical certificate as well as the hospital. What is this? Page 22.
Medical advice tip for
Huh?
advice tip.
No, as well as the prescription dated 12/2/2017 of the Demo Primary Health Center Community Health Center. Full stop. Pursuant thereto, the record reveals that by an order dated 17/3/2017, the Deputy Director Issuing Authority, Food, Civil Supplies and Consumer Affairs, Sagar, passed an order holding that his reply filed submitted by the petitioner was not satisfactory, for which by the said order dated 17/3/2017, which had been impugned in the instant proceedings, the license of the petitioner was cancelled. The record further reveals that the petitioner had duly submitted a representation before the Deputy Commissioner, Sipsagar. However, the said representation having not been taken note of, the instant writ petition was filed. This court have also taken note of the fact that by the order dated 29/2017, notice of motion was issued. The record also reveals that even after a passage of more than 6 years, the respondents have not filed their affidavit in opposition. This court have also heard the learned counsels appearing on behalf of the parties. The counsel appearing on behalf of the petitioner submits that the said notice have essayed the impugned order dated 17/3/2017, primarily for two grounds. First, that the notice that as per clause 15(2) of the order of 1982, there can be no cancellation of the license without granting an opportunity to the licensee to state his case against the proposed cancellation. The learned counsels therefore submitted that the impugned notice which was issued, the notice which was issued on 23/2/2017 did not at all mention that the said notice was issued in terms with 15(2), in terms with clause 15(2) against a proposed cancellation. The learned counsel for the petitioner further submitted that the license which have been issued to the petitioner gives a right to the petitioner to trade in the commodities mentioned in the said license. Full stop. He further submitted that a perusal of the impugned order dated 17/3/2017 would clearly show that there is no reason so assigned in the said order to the effect that as to why the petitioner's reply was not satisfactory. The learned counsel therefore submitted that it is a well-settled principle of law that when an authority passes an order without assigning any reasons, the said order on the face of it would be arbitrary and accordingly in violation of Article 14 of the Constitution. I've also heard Mr. S.R. Borua, the learned counsel, appearing on behalf of the district administration, on behalf of the respondents who submits, that the petitioner had not replied to the various other grounds, various other violations which were clearly pointed out in the notice, except the fact that the petitioner's shop was closed, except assigning reasons why the petitioner's shop was closed. This court, upon hearing the learned counsels upon parties, is of the opinion that a perusal of the clause 15.2 of the order of 1982 clearly stipulates that the licensing has to be intimated with a notice as regards the proposed cancellation. This court had duly perused the said notice, which was issued on 23/2/2017, wherein there is no mention that the said notice was issued against the proposed cancellation. Rather, it only stated that legal actions would be initiated. Secondly, this court also is of the opinion. Secondly, this court have also perused the impugned order dated 17/3/2017, wherein the respondent authorities do not deal with the reply by giving reasons as to why the said reply was not satisfactory. From a perusal of the impugned order, it only reveals that the reply submitted by the petitioner was found to have been made in a routine manner, for which the so-called reply was not satisfactory. Full stop. Be that as it may, this court is of the opinion that under such circumstances, this court interferes with the order dated 17/3/2017, by which the petitioner's license was cancelled. The respondent authorities are granted the liberty to issue a fresh show cause notice in terms with Rule 15.2, in terms with Clause 15.2 of the Order of 1982, and thereupon, thereby calling upon the petitioner to submit a reply. Upon such reply being submitted, the respondent authorities would be at liberty to take such action as deemed fit in accordance with law. However, in doing so, the respondent authorities have to pass a reasoned order. This court also, this court further directs the respondent authorities. This court further makes it clear that for a period of 90 days from today, the license which have been issued to the petitioner shall remain suspended, and the respondent authorities would be at liberty to take such action as deemed fit within that said period.
Lordship, one thing with regard to the inspection date, Lordship, it should be 14/2/2017 instead of 18/2/17. Actually, what happened, it was wrongly mentioned.
Before parting with the record, this court makes it very clear that this court had not decided on the merits of the inspection, merits of the proceedings, except merits of the interference had been made so on the ground of the principles of natural justice, as well as on the ground that the order dated 17/3/2017 is not a speaking order. Consequently, the respondent authorities shall decide as regards would be at liberty to decide as regards the fate of the petitioner's license, the horse, without being influenced to the observations made in the instant order.
90 days after receipt of the certified copy of this order.
Not
Nine-
90
nine-
days. Today, from 90 days, it starts from today. Because the moment I cancel, you see, a license as per Rule 15 cannot, the suspension cannot extend more than 90 days. So therefore, I have given them 90 days. So today I have set aside. The moment it is set aside, his right to continue becomes. So it has to be kept. Therefore, I pass the order that it will remain in suspension for a period of 90 days. You have to complete it within the.
Sure. Okay.
But you get the order on Monday. It's a different thing. You won't get the order today, but you get the order on Monday.
Got it.
Yeah. Yes, none appears on behalf of the party. None appears on behalf of the petitioner on call. The record reveals that the petitioner the petitioner is not represented before this court on various occasions. Taking into account the above, the instant writ petition, it seems that the petitioner is not interested in for the instant proceedings. Accordingly, the instant writ petition stands dismissed for non-prosecution. Interim orders. Yes,
File affidavit.
they file affidavit.
No.
But affidavit in opposition filed by respond number 4. Oh, no, there's no there. I've not asked them. I've only asked them to bring on. In the meantime, respondents are directed to bring on record such notification, if any, as regards the reservation of forest wherein the petitioners are in occupation. You are enjoying an interim order?
Yes.
Very well. The forest department is not interested, so remain there. Let me issue a rule. Let the matter come up after 10 years and help it. Okay.
I will file affidavit today. It's ready.
I'm not asking about what about the reservation notification?
Yes, sir, we have got it.
Where?
Legible copies we have got it.
In the meantime, respondent are directed to bring on record such notification, if any, as regards the reservation of forest wherein the petitioners are in occupation.
Well, there are 3 notifications. This
Ah.
is the draft affidavit notification.
Petitioners are in occupation of which land?
3 numbers of my lord's TRF, my lord. Proposed reserve forest.
How many petitioners are here?
3 petitions. 3.
3 petitioners in 3 reserve forests.
That was my lord, that was an affidavit filed, my lord,
Yes.
by the dead Darden DFO, my lord.
One is in
Yes, my lord.
Bhaluk-
See, my lord,
Bhaluk
Bhaluk
Dubi.
Dubi, one is in Lokhipur.
one is in Nidhanpur.
Yes.
One is in Kumripara. Hmm? Yes, Mr. Loskor, how did the meeting of minds happen? Huh? All 3 petitioners having 3 different places, residing in 3 reserve forests, have joined together to file 1 writ petition and pay only 1 court fee. How did you get hold of everybody, Mr. Loskor? This is an ingenuity on your part, not the part of the petitioner. Tell me. You have filed your affidavit.
Today will file, my officer is coming, he'll depose, my lord, he'll sign today. Both are there, all right.
Which petitioner is residing in which?
same district, Gwalpara district.
Huh?
Gwalpara
District is Golpara. Should have reserved for Golpara.
All these are proposed,
PRF minus proposed,
not reserved.
not reserved. Final notification pending.
It has been pending from 1959.
59.
So?
Now some.
So no real right can be created in
No, no.
between.
That has gone, madam.
So you first settle up
Yes,
yourself
but
as to
it's-
whether you are going to reserve or not.
Yes, madam, steps are on way, madam. Because there was
Steps.
so yes, suo motu PIL was registered by this honorable court, madam.
Yeah.
As regards, madam.
Because you need the
Yes,
PL only for that purpose for issuing the notification.
no, madam, it has been now been taken care of, madam. We are expeditiously pursuing it, madam.
No, why the forest department is not doing anything?
Answer, madam, I don't have, madam, because
That day I could see your head of the department being pulled out there by the NGT,
my lord.
allotting land. Is it something to do with this?
No,
That
this
is why you don't do the proposed the final notification.
This is
There
different,
has
madam.
to be something. Does it take how much? 59 of the how much? 59 and today is 2020.
One is of
24.
61,
24 here, another 60, 41 there.
one is of
Does it-
61, one is of 87, and one is of
59.
59.
Then? Okay. Mr. B. Gogoi, the learned counsel, D. Gogoi, the learned counsel for the forest department submits that the affidavit as directed by this court has been filed, is in the process of being filed during the course of the day. This court have also duly taken note of that there are 3 writ petitioner, but the court fee of only 1 writ petitioner has been paid. The petitioner, the learned counsel for the petitioner submits that on or before the next day, the deficit court fee would be paid. List the matter again on 5th of February 2024. The registry shall bring on record the said affidavit so filed by the said affidavit which is to be filed by the forest department during the course of the day. In the meantime, the petitioner who have also been served. Have you served?
I'll serve, madam.
You have a copy?
I'll just serve, madam. That was the copy for him, madam. I'll serve. madam.
The petitioner, if so served with a copy, would be at liberty to file a reply.
Follow.
The deficit court fee shall be paid on or before the next. Yes. None appears on behalf of the petitioner on call. No, this shop must have been closed. That is why the petitioner is not representing. 31.
Yeah.
None appears on behalf of the petitioner on call. The record further reveals that the petitioner had not been represented on the earlier occasions also. This court have also duly taken note of the submission of Mr. S. Borua, the learned counsel appearing on behalf of the petition, that in view of the government policy to tag all fair price shops having less than 50 ration card holder, nothing therefore survives in the instant proceedings. So taking into account the above and more particularly that the petitioner is not represented, the instant petition therefore stands dismissed for non-prosecution. Same orders, if any, stands vacated.
Well, in both these matters,
Uh,
by the earlier order, the forest department was directed to by the affidavit. When I checked the record, the difficulty comes in because
Both the
initially,
petitions have been filed by way of challenging the order whereby the range officer Soikwa Yuman had directed the petitioner to shift the fish selling auction center to Samara place as the present location of fish selling is inside the by responding on the head that I can maintain and regard the shop premises. Although a stay has been operated for they have not yet to file any activity on approach. It is in the forest is also not represented when the matter is not concerned in the matter in second. Yes,
Difficulty comes in because initially the government advocate had taken notice of the forest.
that is okay. We are not
Subsequently,
ready.
they named
We are not concerned with that.
No.
You see, it is the government who have now bifurcated the various parts.
I'm just placing.
No. If the government has bifurcated, it is the duty of the government also to take appropriate steps by filing appropriate wakalatnamas or applications that he or she would be representing the government. And if they don't appear out there, this court is not going to sit out there and look out there and find out where Mr. Digugoi is.
So even by virtue of bifurcation, if Lord Chief indicated this, even the cause list doesn't reflect. The forest
This is not,
department also.
this is not required. You are to take the step before the registry.
No, what I'm submitting, my lord, had been shown at forest department. We could have come and we could have been knowledge, we could have filed affidavit. See, my lord, see the cause list reflect on G Assam.
Absolutely.
How
So,
can we,
no.
my lord, we don't know. My lord.
When you bifurcate, just for example,
Ah,
as
yes,
of now,
yes.
the fishery department is not bifurcated. Okay?
Mhm.
Now tomorrow, the government takes a decision that we will bifurcate. Is it the registry out here who will make the corrections? No, unless you go there and say that we are representing the fisheries department and as such, so our names in these cases. You have the files with you. And if the government advocate does not give
Ah,
it to you, then
Yes,
it
my
is
lord.
your
These file
lookout.
was- These file was not with us, fine.
So take a case, file a case or against the government advocate. Huh? If you don't do that, then why haven't you filed your written affidavit?
I was not in knowledge, my lord. This whole, my lord, the party structure also reveals forest is there, but the cause list doesn't reflect anything. There's some
No,
material should be there.
Mr. Gogoi, am I to again explain it to you in the in Assamese language? This court is not going to make this. It is made very clear out here. The government wants that, okay, now we are going to have a forest department. Very well, have a forest department. It is your duty, who is now the councils, to file application that these are the matters where we are representing, and as such, our names may be reflected. You file an application. If you don't do it, then it is your lookout. Now, no affidavit filed.
Now I'll get the brief. Now I can get the brief. Today I will only I came to knowledge that this is the
You will
brief.
get
This
the
is
brief from whom?
either the petitioner or the government. I'll let to them hand over the brief. We'll file the affidavit, whatever is required.
Now they are running their shop.
I don't know. I don't get the brief also with me.
No, I also don't know.
But-
I'm
I don't know.
from the last order which I am saying. They are running their shop from Dibru Soikwa Forest. You are permitting. So there is a status quo order. We make it absolute. Keep on running it. If the government is not interested, we issue rule.
My lord will give us the one chance because my lord, what happened, this is a seems to be a protected area.
So what?
So if
What
these-
is this protected area for you?
if
You
these-
don't care even
No,
to
no.
file your, you don't care in to make the final notification for 74 years. So for you, the forest department, you are not bothered.
Uh,
Here you are not
now-
bothered. Now I'm asking you, this is a Dhola Bozar out there at Soikwa Anchalik Panchayat.
My lord.
That is their say. The forest department has taken action out there that you fall within the Dibru Soikwa. Is the department not bothered? The officials are not bothered to see that these matter. Okay, I understand. Your colleague may not have given the file, but is the department not bothered that there is an interim order which is operating by which the forest area, there is a market which is going on?
They had to be acknowledged. So let me have some instructions. What is going on actually, my lord, and what has happened, my lord? In the meantime, eco-sensitive zone has been also been notified there.
So, if you don't want to do it, I can't
No,
help
I'm
you.
willing to do, but only today I came to know that this is going on.
Mr. D. Gogoi, representing the Forest Department, submits that he needs an accommodation for how much?
It is 2 weeks.
Accommodation of 2 weeks for filing the affidavit in
Well.
opposition. List the matter again on 26th of February 2024. Full stop. The affidavit be filed by 12th of February 2024. The petitioners, if so advised, would be at liberty to file their reply on or before 23rd of February 2024. Interim order so passed earlier shall continue till the next day.
Name may be reflected. Name.
Absolutely no.
But only GS
Mr. D. Gogoi, the learned counsel appearing on behalf of the Forest Department, submits that his name may be reflected. He is given the liberty to approach the registry by filing appropriate application.
Obliged, my lord.
Demo. 20. Yes,
If the lordship matter may be taken up for hearing. The matter may be taken up for hearing.
this court have duly heard the learned counsels appearing on behalf of the petitioner and have also perused the contents of the instant proceeding. The writ petition is duly admitted. Thereby, a rule is being issued. List the matter for hearing in its usual course. 23. None appears on behalf of the petitioner on call. On 21/12/2023, when the matter was listed, the petitioner was not represented. And this court made it clear that if the petitioner is not represented today, the instant writ petition shall be dismissed for non-prosecution. However, today also, as the petitioner is not represented, the instant writ petition stands dismissed for non-prosecution. Interim order so passed stands the case, if any, stands the case. Yes.
Trustee, so far the good of the court concerned, I need some more time to file my affidavit.
Why?
Otherwise, Lordship, dispose of the case, Lordship, directing the authorities to Lordship pass the order as per the Lordship considerably. Lordship, otherwise admitted amount, Lordship.
Amount is admitted.
Lordship.
So you pay? Why Tamsar Ali?
Lordship,
Tamsar Ali is a matter with PWD. Pay within 4 months,
Lordship, may say 6 months, Lord.
3 months,
Lordship, I am just praying because Lordship.
3 months.
Let them pay in Chittoor. Let them pay in Chittoor.
Interest disposal not.
Don't pay the lakh total by
So what?
the lakh total.
No, first of all, why have you filed a writ petition? The amount was due when?
In 2017.
2000?
They have made.
No, Mr. Sharma.
They have made some payments in 2014. Then some payments were made subsequently. Where they are making part payment, and after that, they stop the payment.
Understood. When was the last payment made?
2014.
2014. If it is in 2014, why did you file the writ petition in 2018?
No.
How can there be a question of interest?
My lord,
Interest not
so
possible.
long time. They have.
That is, you should have immediately moved the civil court.
So long they have result amount, my lord. So
No interest, sorry.
Illegally, my lord,
Illegal, whatever may be. First of all, then in that case, if you are on the interest, I will dismiss it on the ground of limitation.
No,
You want that?
limitation is there.
No, tell me, how is it limitation is there? The last payment was made in the year 2014.
My lord,
Have they in any manner expressed that they are going to make the payment within the period
Yes.
of limitation? Where?
after that also, there are separate.
No, where?
There are several communications, my lord.
When is the last?
My lord, let's see, 2016.
Hmm.
That is my lord. And next year 4.
Hmm.
Page 57.
Hmm.
Withdrawal of ST money for ST money.
Hmm.
Part of the payment for ST money, they have directed to make payment of the ST money.
Hmm.
When check was issued, but check was not honored by Treasury.
Hmm.
Yeah.
This is in 2016. Then
17 is limitation is there.
Then
18 is limitation, limitation is there.
then
18 is there. Then thereafter also, my lord, NHL number 8 page 65 my lord. It is 2112 as per your order number under request, I have submitted check amounting to 2,43,000 in favor of Maheshwar Thakore for withdrawal of ST money to Rangia subscription, but they have returned it with objection enclosed herewith, which is self-explanatory. That means Rangia Treasury says that we are not going to pay the amount because it was deposited in Guwahati Treasury. That is there.
Treasuries are not party held.
Huh?
Treasury are not party held.
Then nine.
no. First of all, you see, no, Mr. Sharma, executive officer, executive engineer stating out there or admitting any amount would not suffice as an admission. The admission has to be by the chief engineer.
My lord, chief engineer has admitted.
Where?
Chief engineer admitted. Chief engineer paid to the chief engineer written to the under secretary of the government of
Where is that?
from this Executive 4 page 57.
Page
57. 29/8/16 from chief engineer to the secretary of government.
Okay, this 2,43,000 is okay. Then remaining?
Then remaining amount, executive engineer has repeatedly sent the matter to the chief engineer.
That is not an admission.
Matter is pending 15. They have not replied till now. Till now there is no affidavit. So my lord, what can we do? Till now no affidavit. And my lord.
So only direction therefore I can give is payment of interest at 18% on this 2,43,000. And remaining they will verify and pay. Interest, this is the SD money, he is entitled to the interest.
Lord,
At the and the exclusionary clause would only remain in respect of
principal.
the principal amount, but not on the SD amount. The instant petition has been filed by the petitioner, claiming an amount of rupees, claiming a direction upon the respondent authorities to pay the amount of rupees 7,89,262.
Yeah.
Which is the amount due against the final bill number RA/Roman 3/591/5 dated 6/6/2009. And also,
Commission may make lot.
and a further amount of rupees 2,43,396, which is the security deposit lying with the respondent authorities
In fact, Lordship, the
in
respondent
respect to the contract in question.
I'm sorry, Lordship. The irrigation department has deposited the money to Treasury, Lord. Treasury rejected the Lordship, returned the. So on our part, Lordship, we have returned. Lordship. Treasury, Lordship is now the problem is.
No, that is your lookout. You are to pay the amount to him.
Lord.
as regards this.
Look.
As regards the 2,43,000, if he is entitled to, you have to give it. The facts as could be discerned from the writ petition is that the petitioner herein was issued a work order on 5/11/2007 for modernization of Sukla FIS under NABARD RIDF Roman 11. Modernization and reconstruction of X drainage work at chainage 16100.00M of Canal D. The petitioner duly completed the work and was issued a certificate of completion stating inter alia that the work was completed on 20/10/2010. Thereupon, the petitioner, who was required to maintain the work for a period of 1 year from the date of the completion, also carried out the said formality. Upon the said, the petitioner was entitled to the refund of the amount of rupees 2,43,395, which was deposited as a security deposit, and further an amount of rupees 7,89,262, which was the amount to which the petitioner claims is entitled to as the final bill amount. The record reveals that the amount pertaining to the security deposit of that is rupees 2,43,395 was duly admitted by the respondent authorities, and in fact a check was also check or what is the check or pay order.
Check to the secretary.
And in that regard, a check was also issued by the department to the treasury. However, the said check was not honored by the treasury. The record reveals that since Since 30/11/2016, the said security deposit amount of rupees 2,43,395 had not been released to the petitioner. It is also seen from the records that the respondent authorities have also duly admitted the amount of rupees 7,92,089,262 as there has been various communications so issued by the concerned respondent authorities to the petitioner as on 28/6/2018 also. However, as the said amounts were not paid, the petitioner was constrained to approach this court by filing the instant writ petition. I've also heard the learned counsel appearing on behalf of the parties. Mr. S. Sharma, the learned counsel appearing on behalf of the petitioner, submits that the petitioner is not only entitled to the amount which had been claimed, but would also be entitled to the interest on the said amount at the present banking rate, taking into account that the respondent authorities have most illegally deprived the petitioner of its dues for reasons best known. He further submitted the instant writ petition pursuant to the filing of the instant writ petition and notice being issued on 24/9/2018. The respondent authorities have also not filed the affidavit in opposition denying the amounts. I've also heard Mr. N. Upadhyay, the learned counsel, appearing on behalf of the irrigation department, who submits that in the contract there is a clause
Payment will-
which clause?
Payment will- tender. Payment will be made as availability of funds.
Any clause is there?
Because,
Exclusionary.
look,
Maintain the work order.
Hmm?
Open work order.
got the page 26. Payment will of yield of the work would be made when fund is available from the government. Okay.
Submits that as per the work order which was issued to the petitioner, it was specifically mentioned that the payment of the bills of the work would be made when the funds are available from the government. And as in the instant case, the funds are not available. And as in the instant case, the petitioner, with his open eyes, has accepted the said work order. The petitioner cannot claim any interest on the said amount. Upon hearing the learned counsels for the parties, it appears that parties, and also upon perusal of the materials on record, it appears that the petitioner is entitled to the refund of the security deposit upon successful completion of the work in question. There is no denial to the fact that the petitioner did not complete the work, and also pursuant to the completion had also maintained the work for 1 year. The record further reveals that the responding authorities have duly admitted that the petitioner is entitled to the amount of rupees 2,43,395 on account of the security deposit. It is the opinion of this court that payment of the bills for the work so done stands on a completely different footing from the question of refunding the security deposit. Full stop. It is there under such circumstances, this court opines that the petitioner is entitled to the amount of rupees 2,43,395 and also interest on the said amount with effect from 30/11/2016.
What year?
That is the date on which the department had agreed for the withdrawal of the fund from the security deposit. As is envisaged in the communication dated 30/11/2016. However, as regards the other amount of rupees 7,92,000 or 7,89,262, the record reveals that the engineer in charge have duly certified that the petitioner is entitled to the said amount. Be that as it may, there is no certification given by the chief engineer in that regard. This court have also taken note of that if the petitioner is entitled to the, if the respondent authority have taken the work from the petitioner, the respondent authorities cannot deny the payment or the dues to the petitioner on the ground that they don't have the funds. A delay in disbursement of the amounts beyond a reasonable period makes the actions of the respondent authorities unreasonable and unfair, and thereby attracting violation to Article 14 of the Constitution. Under such circumstances, it is the further opinion of the court that the petitioner's dues, if any, in respect to the work in question, has to be paid within a stipulated period. The said amount to be paid to the petitioner on account of the final bill, however, would be subject to certain verifications to be carried out by the respondent authorities, taking into account that the engineer, the chief engineer, have not certified the said amount. Accordingly, the instant writ petition therefore stands disposed of with the following observations and directions. The petitioner, the respondent authorities, and more particularly the chief engineer, which one? Chief engineer irrigation?
Irrigation.
Huh?
Chief engineer irrigation.
Irrigation. That is the respondent number 2 is directed. The respondent number 2 with the following directions on. The petitioner herein is entitled to the amount of rupees 2,43,000 so and so on account of the security deposit with effect from 30/11/2016. The petitioner herein would be entitled to interest at a rate of 8% from 30/11/2016. What?
Admitted was on 29.
29?
It-
It is from that letter of the irrigation
Yes.
department, na?
From
That is
the-
of 30/11.
30/11.
30/11.
From the letter of chief engineer, my lord. From chief
Not
engineer-
from the chief engineer, from that the document where they have given.
Page 61, Lord.
Accordingly, this court therefore directs the respondent number 1 and 2 to take effective steps for release of the said amount of rupees 2,43,000 so and so, along with interest at the rate of 8% with effect from 30/11/2016 till the date of payment. The said respondent shall ensure the payment is made not later than 3 months from the date a certified copy of the instant order is submitted. This court further directs, number 2, this court further directs the respondent number 2 to verify as to whether the petitioner is entitled to the amount of rupees 7,89,262 as so claimed, and which has been duly certified by the engineer in charge. And upon verification, if it is found that the petitioner is entitled to the said amount or any part thereof, the said be paid to the petitioner. Full stop. The said exercise in respect to the amount of rupees in respect to the said exercise be completed within a period of 4 months from the date a certified copy of the instant order is served. Full stop. With the above observations, the instant petition stands dismissed.
Obliged.
56.
Yes. Don't see the other side.
But I have the instruction law.
Come up with your instruction. What is the instruction?
But there is some allegations against the petitioner's father lawsuit. He has not regularly distributing all the SK oil. That is the reason lawsuit. Subsequently, petitioner's father was the license was the initial lawsuit.
None appears on
May-
behalf
may
of the
please
petitioner on court. Huh? Yes.
Lordship, the petitioner's father was running a FP shop for 40 years.
Then
And after his death, his legal hat, his son applied for the license. But instead of him, respondent number 5, but they have issued a license.
6. Respond number 6 was issued. Okay, then tell me. You don't know the facts. I'll make it clear. Okay, then next what happened? Why are you alleging? You have a right in eternity or a perpetual right. Is the right for a license is perpetual? Or is it hereditary? Yes. Mr. Counsels for the departments.
Lordship, kindly see page 65 of the registration law.
Page 65 of the registration.
65.
Okay, yes. Government has decided to give priority preference to the department property of women and ex-servicemen and legal heirs of the bishop in the matter of plotting fair price law. As per the government, you are therefore requested to give. Okay, then
Lordship, petitioner's father expired lawsuit. After his death lawsuit, that this self-help group applied for this license lawsuit. And after lawsuit, there is some complaint against the petitioner's father lawsuit.
there is
Complaint, the public complaint lawsuit.
so the public complaint. How will they know? How will they know? You must have informed him that your right which was there, some right of preference, is being taken away because your father was not good. Have you informed him?
That is, his inquiry was conducted lawsuit.
So have you put him to notice? Eh? How is it possible you do all these things in this manner? And who is appearing for respondent number 6? Have you served?
Name should not stop.
Pursuant to the order dated 29/11/2023, Mr. N. Goswami, the learned counsel appearing on behalf of the respondent authorities duly submitted that there were certain complaints against the father of the petitioner when the father of the petitioner was the license holder, for which the petitioner was not considered in spite of a preferential right which the petitioner had in terms with the communication dated 1st of April 2005. Taking into account the above, this court is of the opinion that such aspects needs to be brought on record by way of an affidavit and has to be based upon some records. Under such circumstances, the district, who is going to file?
Lordship, that is Deputy Commissioner, Lordship.
Under such circumstances, the respondents herein are directed to file their affidavit in the matter by 12th of February 2024. This is the matter again on 19th of February 2024. Infructuous?
Yes.
Mr. Your name?
PP Sharma.
D.B.
PP Sharma.
Okay. Mr. B.B. Sharma, the learned counsel appearing on behalf of the petitioner, submits that the writ petition has become infructuous. Why?
It was regarding non-payment of contextual bill. We have received that.
Has become infructuous in as much as the petitioner have duly received the contractual bills in question for which the instant writ petition has been filed. Taking into account the above, the instant writ petition therefore stands closed as it has become infructuous.
Obliged.
May I please?
Mr. Sharma.
My lord, in this case, petitioner has a plot of land on the bank of the river Durang in the district of Pukrada.
Where?
State.
Bank of River?
Pukrada.
Okay,
River
then.
Durang at Pukrada.
Hmm.
He applied for permission to remove land for his own purpose. That was not allowed.
Oh.
Subsequently,
This matter came up before me earlier?
yes.
Yes.
Subsequently, because my lord, there was
Be that as it may, a final opportunity given to file a reply. You file your reply?
yes, fine.
Okay. Your question out here is that this particular land they are excavating in your land.
Someone else is excavating, and my lord, sometimes we have not been allowed to extract land from soil from the state land, my lord. And my lord, lordship will kindly see my reply. Reply, my lord, page 46. They said that if permission is granted to me, that there may be erosion in the plot, state area, and there may be diversion of the state river, my lord, into the other city.
But they are allowing others.
Yes, my lord, page 46, my lord.
Yes, who is appearing for this?
No, my lord. Recently, I have recently got, and 23, my lord. They have allowed.
Who is for BTC?
Sanjan Pal.
Oh, none appears for the BTC on call. Okay.
One another.
When a matter has been taken up, the learned counsel for the BTC is not present. For the interest of justice, the matter stands adjourned to be listed again on 5th of February 2024. It is made clear that if the BTC or the council, standing council for the BTC is not represented on the next date, the instant writ petition shall be disposed of. It would be taken up for disposal on the basis of the materials on record and after hearing the learned counsel for the petition. Yes.
May I please, your lordship? I am appearing for response number 1, lordship. You have multiple board, lordship. Lordship, matter relates to we granted the building construction permission to petitioner, lordship.
Matter relates to?
With construction of building, lordship. We granted permission to construct building to petitioner.
To set aside and quash the impugned notice dated 20th of
Your lordship, kindly see order 2411.
Lordship.
24/11/2020.
Oh, yeah. There's total appearing on behalf of the next committee. That part it. Appearing. Yes, you file your reply.
No.
If you have the Jorhat Municipal
Yes,
Court.
my lord, that I have filed, my lord. That is on record, my lord. That is they have received long back in 2019. And your lordship can receive para number 1. They were asked to file, my lord. The lead petitioner was asked to file their sale deed as well as mutation
No,
order.
no, madam, on the last occasion you said that they are not filing.
No.
No, Lordship, on last occasion, Lordship perused the record. of
I have
the
perused the
petition.
record, but
And after that,
your
you-
specific submission was that matter could not be concluded by them, by the authority, on the ground that they are not filing their reply.
I have filed
Yes,
reply,
Lordship.
my lord. I have
They-
reply, my lord. If your lordship required, I'll file in by way of affidavit.
Not necessary. Yeah.
Lordship give direction to file additional affidavit. To file
But that is a
petition.
different thing. The additional affidavit has been directed to file to produce on record what is the document of title they have
Lordship.
and any mutation orders being made. They have not filed.
That is long back in 2019. I have filed our reply.
So
We have
you do one thing, you decide as they have filed their reply. You decide. I give you the liberty to decide. Better off. And we'll have it on the next date. If they don't file, we'll dismiss for default.
Right.
And in the meantime, you take a decision. You have filed. None has appeared on behalf of the petitioner on call.
The order.
Full stop. The petitioner had also not filed the additional affidavit. No. He has filed some reply. He has filed a reply on 11/12. Have also not filed the additional affidavit as directed by this court by the order dated 24/11/2023 and closing therewith the documents of title of the petitioner as well as the mutation order made in favor of the petitioner pertaining to tag number 4107 and 4108 included in KP Patta number 334. It is, however, relevant to take note of that an affidavit in reply was filed by the petitioner on 11/12/2023. Be that as it may, it is also pertinent to mention that pertinent to take note of the submission of Mr. T.J. Mohanta, the learned senior counsel, appearing on behalf of the respondent number
2, my lord.
respondent number 2,
Two.
who submits that the petitioner, the respondent number 2, had also had as far back as on 6/6/2019 had submitted the reply before the chairman Jorhat Municipal Board. So, taking into account the above, this court finds no reason as to why the Jorhat Municipal Board should not take up a decision as the replies have been duly filed by the authorities, by the respective parties. Full stop. This court, however, this court, in the interest of justice, is not taking up the matter for disposal today, as the counsel for the petitioner is not represented. However, on the next date, if the counsel for the petitioner is not represented, the instant writ petition shall be dismissed for non-prosecution. This court further makes it clear that the pendency of the instant writ petition shall not be a bar upon the Jorhat Municipal Board to take a decision on the matter pending before it. List the matter again on 16th of February. You take this.
Party. My lord, this is a case relating to one of the events of the provisional attachment order by in the PMLA Act, my lord. I have filed an additional affidavit today morning from the record. I think it takes some time. Can it be?
No. First of all, you tell me why the writ proceedings should be initiated.
There is no bar, my lord.
No, there is no bar, understood. But you see, as that day I was going through the judgment of the Telangana High Court. The Telangana High Court did not say that these requires to be placed along with the reasons has to be a part of the the order or the complaint. It does not.
I'll place it in a different way, but because the 5 and 8 it has to be read together. If you read 5 and place it together, it has to be reason has to be recorded at every.
No. There's no quarrel that the reasons has to be recorded.
Yes.
But the reasons need not be a part of the complaint.
No, my lord. If you read the 8, my lord, it has to be reason has to be in the complaint.
So
Because it
let
has
us
to be
see that.
the second part of the 8. The 5 is there is no necessity, my lord. It has to be because the second part of the 8, when the notice will come to me and the option is given to me, that has to be in the somewhere in that from the any kind of information, the second part. That is my argument.
Show me that.
The adjudication on receipt of a complaint, that's very important. Under the subsection 5 of the section 5, the application manner section 4 and 2, the adjudicating authority has reason to be believed, that's important, that any person has committed an offense under section 3, it may serve a notice of not less than 30 days on such person, calling upon him to indicate the source of his income, earnings, assets, out of which, by the means of which he has acquired the property attached under the subsection 1 of subsection 5. Now this is important. Or seized or frozen under section 17 or section 18, comma, the evidence on which he relies. This is my argument.
No, the evidence on which he relies on who?
That the adjudicating authority.
No.
No, yes, well, I don't have the evidence. That's why in the complaint, the evidence he relies or seized, evidence he relies on other relevant information and particulars, and to show cause why, and to show cause. The show cause will be by, I cannot show cause, my lord. He has to show cause, and to show cause why all or any such properties should not be declared to be the properties involved in the money laundering. So my contention is that apart from the notice, the other material has to see where that reason has been recorded or what is the reason behind. That is my humble practice. And that's on that line I want to place the material. Can it be on the next day because lordship is rising at it takes some time. And I have filed an affidavit, the complaint.
No. First and foremost, the question is, why should this court entertain? You have a fair to reply. You can very well reply, and after that, if any order is passed, you have section 42.
Yes, my lord. Now,
And
that question now, it has admitted, my lord, come for hearing.
At the initial stage
It
of
has
this,
not been admitted, it has come
No,
up
no,
for
it-
admission.
But anyway, it was not vacated on that line. They have filed the vacating order also within 180 days. That has not been done, my lord. Now, again, going back to the adjudicating authority.
No, obviously, why should this court
Well,
exercise
that
jurisdiction?
has this court has the power. It's not
No,
that this
this
court
court
does
should
not have
not
the power.
exercise the power. Power may be manifold, but why should this court exercise?
Because
Even if you see the judgment
No,
in
no,
the
no,
Telangana
that's
High
a-
Court, that came in appeal after
No, no, that's a
42
different.
appeal.
But there are other high courts has adjudicated the matter at the initial stage itself. And the lordship can
Let the
listen one
other high
thing.
court do it. I'm not bound by the other high
No, no,
court.
that's a different issue, my lord. That your lordship is not bound. I'm not
Your
saying that.
issue out here.
My only lordship kindly listen to me. Why the writ court has to be, because the moment this is attachment, this is a draconian law. Lordship is no that. When it is the draconian law, my right is immediately taken up by the adjudicating authority or by the issuance of the notice. They can immediately seize my property, immediately attach my property. That my right goes immediately, so that my option immediately come before this court. That's why his lordship has to exercise this power to prevent the abuse of the process of the court.
These were
And-
very much argued in the judgment in Vijay Madan Lal or what is that, the
Vijay
judgment which
Madan.
went to Supreme Court. These were various aspects which were duly argued there.
Yes,
But
yes,
then also
because
the
the
Supreme
lordship
Court
has
did
to
not
see.
say
So
it's to
the
be
facts
bad.
of each case is different. But in the PMLA Act, when the person's property has been attached and lordship has seized, the one property which doesn't even fall within the parameters of the PMLA Act, which is beyond the jurisdiction, that was not only under the Act when it was acquired. And so without application of the mind, they have attached my property to the one property, which is a major property, which I am enjoying. And that property, even at that time, at the relevant point of time. it
No,
was
what
not
is the
under-
effect of attachment?
So I will losing my duty. I can't do anything, my lord.
What you can't do? The possession remains with you.
Possession sometimes,
No,
but the
you want to
possession
sell it?
remains with, but the
No.
ultimately,
One property is of 1997. You want to
maybe,
sell
but
it?
that is why.
No, you want to
So,
sell that.
No, whatever
That
the
is the only
reason,
thing you can do.
no, reason is different. I
Yeah.
cannot sell that, my lord. I
I
cannot
would have
sell any of the
understood that
property.
your entire bank account have been seized and thereby you are not in a position to do anything. That is another aspect
So
of it.
that's why, my lord, the property which are involved.
So the property which we are in question of is of 1997 is a immovable property. And
Yes,
if you
yes,
see
even
Indian
that property, if it is seized, my lord, the lordship has to interpret it that. And that's why the interim order has been passed.
the
and the
interim
interim order
has been passed.
And
This court-
thereafter,
this
subsequently,
court
lordship,
is not
the
in
vacation also
agreement
filed.
with that
My
particular
lord,
thing.
they have filed the vacating order also.
Forget about the vacating. This court is not in agreement with the interim order. Any interim order is there. I'm not bound by the interim order.
No, I'm not saying that thereafter they have filed the vacation. The vacation they have not vacated. Now it is in the final stage of the adjudication. Now lordship can give me the some time. Then
I'm giving you.
so I have to place the whole thing from the beginning, my lord. If lordship want to hear it, that's a different issue, my lord.
Yes, please tell me.
So
I'm
I
there.
have filed an additional affidavit also today. That's all, my lord.
No, it's okay. It's an affidavit. You have a copy of it.
No, I have filed today.
Understood? You have a copy of it.
Yes, yes. That's why I'm saying it. That's why it will
I would
take
have
some
understood
time.
if they file an additional affidavit, you may not
No, no.
have a copy of it. You have a copy of it.
Yes, yes. So now let us start from the section page. Now, my lord, the order. Now, provisional attachment order, my lord. This is dated 24/6/2020.
Hmm.
Page 33.
Yes.
Now, first of all, my lord, paragraph 16.
16.
16. 16 onwards, my lord.
It's not very important. It's in 70. And whereas, upon careful consideration of the material placed before me, I have reason to believe that the offencer is involved in the money laundering, and if these properties are not attached immediately, and non-attachment of the state property is likely to frustrate the proceeding under the Act. This is the reason that has been cited, which we have said initially. So my first contention is not, this is not the sufficient. There's no objective satisfaction of the treatment offered. Because there has to be, he has to, from where he has come to this finding. This has to be recorded in this particular his objective satisfaction.
The objective satisfaction would be on the reasons to be, which
Yes,
is being
why he has
recorded in
reason
the
to believe, madam?
Now, is it required to be put out there in a notice?
Not required, but it has to be on the record. In the first place. But it has to be at the every state they have to follow.
Yes.
This principle.
No, here we are concerned with this particular order.
Yes, this particular
In
order,
this
thereafter
order,
subsequent-
whether there has been a reason
Because-
to believe there is an existence of a reason.
Yes, sir. So there has to be a nexus. There has to be a nexus of his belief and the material fact under which he has come to this point. That has to be spelled out in every. It can't be an ipsa dicta of his belief of his. So that's the basic principle. Now this is not required to, but this has not been done. This is not the only where from I can understand. This is the from where I can challenge this order that if they have the in the file, if this has been recorded, that's a different thing. But Lordship has to see that this has been actually been recorded. Now, this has been forwarded accordingly. Thereafter, again the notice has been issued by the adjudicating case under section 8 of.
But that's not a part of the instant.
That's why this is the affidavit I have filed.
Understood, but that is not a part of the.
Initially not part of.
We are
Yes.
concerned now. That is a separate process.
Yes.
Because after within 30 days, they are to move the adjudicating.
Yes.
And if the adjudicating
No,
authority,
adjudicating authority within 30 days after the completion.
whatever, if they do it in that manner or this manner, that is a different thing.
Ah.
It is-
Well, they did it and they have also given this notice to us within that period of time. But initially it was not with us. And now I have filed that additional part also. That the additional part also, the second part, where the adjudicating authority applies his mind. If I go back to the adjudicating authority now, that's why I'm saying, madam. If I go back, again the same thing, madam. In the adjudicating authority, while issuing the notice under section 8, they were also supposed to give me the complaint. The
they
file by
are
them.
supposed to give the
Complaint petition which they have filed to the adjudicating authority.
you have not received the complaint.
We have received that. We have an expert with the additional. Now that's why I'm saying, in the complaint and the notice by the adjudicating authority, they are absolutely silent regarding the reason to believe again.
But that's not a part, Mr. Bora. That is not a part of the petition. By way of an additional affidavit, you can't bring those
See,
aspects.
that is my additional submission, my lord. If I go back to that, my lord, this same
That
thing
will
will
be a
happen.
fresh cause of action if you.
The fresh
want to
cause of-
file
maybe
it, that's a
fresh cause of
different
action,
aspect
but
of the matter.
there cannot be a fresh cause of action because they have already initiated that part.
No, no, understood. But shouldn't that be a fresh cause of action
Fresh cause of action may be for me, my lord,
for you?
for me, but
For the
they have
purpose of
already done
challenging-
it. That's why I'm saying they have already issued the notice. The complaint already, so lordship can see that the whether now again going back to the adjudicating authority. That's what I'm talking about. Again, it's a
No, because you have a right.
No,
You
I have a right, my lord. Well,
Now,
but
what is the problem in going before the adjudicating
when the
authority?
lordship can exercise these
Why
powers,
should
my
this,
lord.
no, the question of exercising this extraordinary jurisdiction
No,
is not a right.
No, sometimes the lordship has to see to give the proper judgment because this is apparently on the
Yes,
law.
if it was only.
And the lordship
No,
can see
Mr.
if
Mr.
there is
Bora,
a no,
if it was
lordship, then-
only that 97 property was there, I'm just giving a. If it was only the 97 property was there, very well, I would have done it on the basis of that notification. Only the 97 property.
So 97 is a part of it.
Understood. But then also you have a right now to
No,
say,
that's I have a right, but that's a different thing.
you have a right to submit your
No, no,
proposal
my
against that.
contention is that, madam. I have exercised the right before your lordship. And apparently, if the record does not say, they have not given it to me. If the record does not spell out the reasons, then lordship can interfere definitely.
In fact, Mr. Bora, I would have asked you to argue the question. On the last occasion also, I've seen from the record that there are reasons. Now, therefore, the only thing which I think you need to argue on is that there are two aspects. One is recording of reasons will be there. They have done it. Now, once the reasons are being recorded, the existence of the reasons or the fact of it may be a question of the very existence of the reasons are not. Reasons have been recorded, but
I don't know, my lord.
the
That's why I'm saying.
existence of the reasons has to have a rational nature with
Yes, with the property council.
with the property.
So that's what my
And
saying.
the second is, but as regards the sufficiency of the reason, this court constitutes.
But sufficiency, that's a different issue. But the absolutely silent regarding their findings to that effect in the record, if where from they have come to that finding, that if the record does not spell out anything, is only the
The
subject
record
is
is
satisfaction, my lord.
Mr. Bora, the record spells about the reasons. You are to therefore show it that under no circumstances there can be any reasons to believe.
So where from they have gathered it that they have to also spell out, my lord. That part is their part. That these are the reasons for where we have come to the finding. This is the reason why we are trying to attach the property. That is their duty, my lord. It's not my duty.
No, they have, you see, from
What
this.
reason they have, why they have come up? They have simply
Mr. Bora, I think I'm failing to make you understand this. Please. You see, you are to place before this. You see, only ground on which this court can interfere at this stage is our jurisdictional error. What is the jurisdictional error? That without having reasons to believe, they have in practice. So you are to therefore show that there is
Yes.
no reason. But if you just say that without having any reasons to believe they are doing it, and they just show me the reasons, then your entire case falls. So
Yes,
your
so that's what the notice they have issued.
it is not
From the
required
notice-
to record the reasons to believe out here. The law is well
See,
settled.
where from this paragraph does not say anything, my lord. Where from they have come up that reason? Only they are saying that this is just a copy paste of the section 3. What is the reason in paragraph 17? Which is just a copy paste of the paragraph. That is can be a reason, my lord. That can be a reason. That is my case. Because that is the only material I have at this point of time. So I will argue on the section 7. Then the paragraph 17, from the 17, there is no reason apparently, my lord. Reason just a copy paste of the order.
Mr. Bora, last time you showed me the judgment of Telangana High Court.
Yes, there
Yes,
are other high courts also,
It's
my lord.
okay.
The Supreme
No,
Court also.
let
The Supreme Court
let us
also
not
recent
go-
judgment and the other judgment.
understood everything. You go through that judgment.
Yes.
More particularly after that Delhi High Court thing has been taken note of, then the Telangana High Court duly takes note of 3 judgments of the Supreme Court in the case of reasons to believe.
Yes.
One is Satyanarayana.
Yes.
One is there. The Supreme Court categorically says in those judgments, you see, the existence of the reasons is the only thing you have to challenge. The existence is there, but the formation of the opinion for the existence is not there is what you are to argue. That is what I'm trying to tell you.
So that's what I'm saying. Apart from these material, where from I
So
argue
you
can
are
add.
to say that from these materials, there cannot be an existence of having a reasons to believe.
Yes, that is
That-
my argument, my lord.
Yes.
Section 17.
But you are not submitting that. You are saying
That-
only
that
a
is-
copy paste.
That is the existence. Where from that from the very beginning I'm saying it's just a aesthetics of the authority. Where from they have come to that finding. That is not there
They
in
have
this
duly
case.
recorded that.
That's finding the 17. Where from they come to that finding, my lord? That's not there. That's my case. Apart from this, I don't have anything at this moment, my lord. And the reasons which property does not belong to their jurisdictional error, my lord. It doesn't have the jurisdiction at all, my lord, as Lordship has said, to attach that particular property. That's another question, my lord. Regarding that particular property, that Lordship has to deal it also. Whether they have the jurisdiction to deal with my dad property, which 97 property, when PMLA Act was not there.
PC Act was not a schedule offense. So it's a jurisdictional case also. They have attached the property. They don't have the jurisdiction at all as per the Act itself. So that's an additional matter. So what I'm saying, madam, the
Yes.
Now you can see the section 5 is very important. The provision to every word is very important. Because they have to show us that every property involved, which they have attached, is involved in the money laundering. The property involved, not the me involving in the money laundering. Here, they are saying the me involved in the money laundering, not the property. But the section says otherwise. The section 5 says, on the basis of material in his possession, if such property involved in money laundering, so I have to acquire that property by money laundering. What? The proceeds of crime, madam. Now, the paragraph 17, what they have said, that
And
they have
it
reasons
says
to
on the
believe that
basis of the materials in his possession, that any person is in possession of any proceeds of the crime.
yes,
And-
provide your second provision.
And such proceeds of the crime
Yes.
is likely to be concealed, transferred, or dealt with in any manner which
one is-
may result in frustrating any proceedings relating to confiscation of such proceeds of the crime under this chapter. He may by ordinary provisionally attach such property for a period not exceeding 180 days from the date of the order in such manner as may be prescribed.
Which one? 5. Lot is
Yes,
reading
5.
I'm
5
going to
A
write
and
the
B.
proviso, madam. The first proviso, madam.
Yes.
Second story, madam. Second proviso.
Anything contained in the first proviso, any
Provided
property
further, madam.
of any year may be attached under the
The notice.
if such property involved
This
in
is-
money laundering
Yes, this
is not attached immediately under the chapter, the non-attachment here. This is the reasons to believe that if it is that property, if it is this property is involved in money laundering. Now, for that we have to go to A and B again.
yes,
Having been a proceed of the crime.
my notice, my lord. what I-
Anyways, we'll do one thing. I'll
My-
accommodate you today. Let's have it on 23rd. You produce the records. List the matter having been heard at length. List the matter again on 23rd at the top of the list. Yes.
That matter relates to about the violation which my learned friend has filed before this court. There was 2 violations, flat 7, flat numbers, my lord, 7, where Assam Time House. So now, my lord, the GMDA says a notice was issued, then it is irregular. So a notice has been issued, we have to justify. Second is very important, where it was sealed by this court. That in my lord, so far as C is concerned, let's see, there was a hotel which was constructed. Your lordship said that how can you construct a hotel in residential complex? Now then, my lord, it was sealed. Then my son's marriage, then we made an application. These were de-sealed. Thereafter, what has been done, my lord, a trade license was issued. Trade license issued by the...
Then they cancel.
They cancel it, my lord. That's the position. So whatever, my lord, demands they have fought for, and your lordship said every right we have got, we have to file an application. They will consider. So, my lord, this virtually his petition, my lord. All relief he has got, my lord. What
Yes,
more, my
yes.
lord?
What remains?
We'll go there, my lord. We'll file application, whatever.
What
is
about the
necessary.
building, demolishing of the other two?
This is they have to take a call.
No, you are not there for that.
Which one, my
The remaining demolition of the building
that's
number
why
2
I'm
and
not, my
3. You are
7
not
crore
there.
is concerned. That his violation is.
And we don't have the GMDA here.
GMD code.
GMDA is not present. Therefore, the matter having been taken up. The record when the matter has been taken up, the counsel appearing on behalf of the GMDA is not present, for which the matter could not be taken up for disposal. So, taking into account the above, list the matter again on 7th of February 2024. It is made clear that the instant matter shall be taken up for disposal on the same date. And if the counsel for the GMDA is not present, the matter would be heard in its absence.
Great. Fine. 34.
Hmm.
This all code was directed.
You have not filed the additional affidavit.
Lost it.
So then?
Article because it's suffering some old illness.
Who?
Now, petitioner lost Rema Bibi.
Uh.
And now yesterday I again made a phone call. She requested to further 1 week time maybe going to be by the
So you are not interested with the matter?
If not interested, the next day lost this matter maybe.
You are not interested, can't help you.
But I quickly requested.
It seems that the petitioner is not interested in pursuing with the instant litigation, taking into account that in spite of various opportunities being granted to the petitioner, the additional affidavit has not been filed. However, for the ends of justice, one more additional opportunity is given to the petitioner. Listed the matter again on 27th of March 2024.
Obliged.
Right.
There's no interim order, Mr. Purva.
Lordship.
Yes.
Yes.
How can you?
Lordship, it is manageable. We have also replied to the affidavit filed by respondent number 7, the technical inspector, government of with record. And in the meantime, I have also gone through some rulings of both of appellate court and this.
What does it say?
It is manageable. So this court.
What does the apex court say? That this court should then go and make an inspection?
Lordship, after
the electrical accidents report gives a submission?
Lordship, first of all, I should go to the fact.
My lord, if I may submit, I have not been served with a copy of the reply.
Why not? After it is being served, only then it is filed.
Huh?
After a reply affidavit has been served.
My lord, it has been served to the government, but not to APDCL.
APDCL, it is a reply to the
You want the money from whom?
APDCL, but
Then?
affidavit was of
Filing affidavit without submitting cost.
Lordship.
5,000?
No, Lordship. Reply is given to
Mr. A. Borua, the learned counsel appearing on behalf of the APDCL submits that an affidavit in reply has been filed by the petitioner, but no copy has been served. The learned counsel for the petitioner submits that he would serve a copy during the course of the day. This is the matter again on 29th of January 2024. You take this, sir?
Obliged, ma'am. In the meantime, Lordship, yes, I am finding.
During the course of the day, not in the meantime. Yeah.
I am finding right.
Yes, Mr. Samaria. For what? Mr. S. Samaria, the learned counsel appearing on behalf of the petitioner, submits that an affidavit in opposition has been filed by the respondent, private respondent, and he would like to, he needs an accommodation for filing a reply. Hey, private respondents have been filed. Where are private respondents? No names have been shown or what? Where?
By way of IML.
Who impleaded?
My lord, that is Guru 9.
You do one thing, file a amended memo of parties also. No, amended file memo. Has filed the learned counsel and Mr. S. Summary of the learned counsel for the petitioner submit that the newly implemented respondent number 3 and 4 have filed the affidavit in opposition, for which he seeks an accommodation for filing a reply. List the matter again on 28th of February 2024. In the meantime, the reply be filed. The petitioner is further directed also to file a fresh memo of parties showing the name of the newly implemented respondent number 3 and 4 before the registry of this court by 24th of January 2024.
My lord, the moment has been directed to produce the record.
We'll see then. I'll first file your reply.
Okay.
And the respondent shall, the registry shall, on filing of such memo of parties, make appropriate changes in the cause title, as well as also upload the same in the CIS. Yes, any information?
My lord. My lord, I have received the
Apply
instruction, my lord.
regard the instructions sought for him. Huh?
My lord, but no, my lord, whereabouts of Dr. Samira has been, my lord. Lordship, I have received the instruction, my lord, though I have asked for only particulars. They have given the status report wherein your lordship will find a page, paragraph 10, my lord, they have stated, my lord.
What is this case, madam?
My lord, the senior is just, he has gone out at this point.
Okay, anyway, you do one thing. You give him a copy, give her a copy of it.
Lordship.
Then she may address this court on the next occasion as to what whether the investigation has not been done properly. And if it is not done, then only the question of a CBI inquiry or something like that.
Now the inquiry is being done by CID.
Mrs. Udas, the learned additional senior government advocate, has placed before this court certain instructions. So, be that as it may, this court finds it relevant that such instructions should be also placed with a copy of the such instruction be served upon the learned counsel for the petitioner. And list the matter again on 12th of February 2022. On which date the instructions which have been produced before this court shall be again reproduced.
Lordship, I'll be out of place. Can it be on before 10?
Your senior is going to do. Yeah? Madam, you take back the instructions. Huh?
Lordship,
Shall be again reproduced, again
37 for order. 37 and 38.
What is this?
Conflict petition docket.
Yeah.
What happened in this docket, the leading counsel, the LP Sharma expired. So I have to take instruction from the client whether, because I'm not equipped to deal with. My senior LP Sharma expired on 8/10/2023.
Huh?
My senior LP Sharma expired on 8/10/2023.
LP Sharma. Okay, then
I have to, the BCC is to me.
the learned counsel for the petitioner seeks for an accommodation in the matter, taking into account the above, list the matter after 2 weeks. Yes. Yes. Any instruction, Mrs.
no, Lordship, instruction not received.
Then you just get me the
Yes.
instruction as regards Sonapur PS case number.
Yes, sir.
Full stop. This court, by an order dated 28/8/2023, has sought for certain instructions as pertaining to Sonapur PS case number 392/2013. However, the said instructions have not been placed. A further opportunity is given to Mr. S. Borua, the learned counsel, appearing on behalf of the respondents, who list the matter again on 16th of February 2024, on which date the learned counsel for the state shall produce the instructions as sought for. No affidavit has been received by them, moreover the third form. Okay. None appears on behalf of the record reveals that the petitioner, none appears on behalf of the petitioner on court. The record reveals that the petitioner had been not represented on various occasions. That is on 2/3/2020, 11/3/2020, 16/10/2020, 25/11/2020, and 9/12/2020. Taking into account the above, it seems that the petitioner is no longer interested in the proceeding for which the instant writ petition stands dismissed for non-prosecution. Interim orders, if any, stands vacated.
41. The matter has become instructed.
The learned counsel appearing on behalf of the petitioner submit Mr. W. Rahman submits that the writ petition has become infructuous. Why?
The market settlement period
As the market settlement period is already over, taking into account the above, the instant writ petition stands closed as it has become infructuous. Interim orders, if any, stands vacated. Okay. I got to none appears for the petitioner. None appears for the petitioner when the matter is called. None appears. Good. This court have also duly taken note of the order passed by the Lozima Court on 15/9/2023, wherein also it reveals the petitioner had not taken steps by way of the state and file an affidavit of service. Further to that, it also reveals that the petitioner was not represented on the earlier occasion. It seems that the petitioner is not interested in the instant proceedings for which the writ petition stands dismissed for non-prosecution. 43. Yes, madam. The learned counsel appearing on the is not aware whether prior notice of order which is to be complied with was to opposite. Yes.
We'll take steps.
Huh?
We'll take steps with
Take steps.
yes for the new impeachment of new opponent.
The learned counsel for the petitioner seeks for an accommodation for taking steps upon the newly taken. Madam, where the problem arises out here is without notice about the order to the newly impleaded person, how can you file this instant IA? Tell me. You want to put the cart before the horse. The horse should be in front of the cart, isn't it? Huh? You file a contempt. Now you are saying that you are going to take steps and asking him to comply. Tell me. How is it possible? That is why I asked you. This cannot be done unless you inform the other side that this is a case of willful violation. Willful when it will happen. He has to have knowledge. You have to inform him, look here, there is an order passed, kindly comply. Without that, how can you impede somebody? The learned counsel appearing on behalf of the petitioner submits that she would not like to press the instant interlocutory application, but rather would take appropriate steps against the present incumbent to the post of post of present to the post of the district commissioner, Dhemaji, by issuing appropriate notice for compliance with the order. Post of taking into account the above, the instant IA stands closed. However, the petitioner would be at liberty to take effective steps, to take appropriate steps as envisaged under law upon the present incumbent to the post of the district commissioner, Dhemaji. IA stands closed.
Regarding non-payment of contractual bill,
You paid?
my lordship will see page 12 of the contempt petition, the part of the order. Petitioner claims that my lord, he has not been paid 22 lakhs out of an amount of rupees 28 lakhs. My instruction says that my lord, 22 lakhs have already been paid in way back in 2006. Only remaining is some 6 lakhs odd. My lord, we are taking steps, my lord. Proposal has been submitted by the chief engineer to the government. Some time may be given to us.
Budget?
Budget will
8?
Hello?
8 is the budget?
Yeah.
We'll have it on 4th of March?
Yes.
Please the matter again on 4th of March, on which date Mr. B. Gogoi, the learned counsel appearing on behalf of the respondent, shall apprise this court as to when the remaining amount of 6 lakhs and odd would be paid to the petitioner. Yes. Oh, Mr. B. N. Gogoi is not here. Yes. You want to evict?
Yes, the instruction not received.
None appears on behalf of the petitioner. The instructions have also not been received. As stated by Mr. S. Burwal, the learned counsel appearing on behalf of the respondent. Taking into account above, let's matter again on 28th of February 2024. Very good. Good night.
We are extremely sorry, my lord. Item number 23. Item number 23, my lord. Please, my lord. I have been told, my lord. Please, court, my lord.
Is it? 23. Why? You have not appeared many times, I suppose.
But today, my lord, I appeared another court, my lord.
No. Earlier also you have not appeared.
Yes.
First time I never dismissed.
Yes.
Earlier also 2-3 times you have not appeared. Then? Okay, to list the matter. 23 to list. What is this? Who is appearing out here?
48.
Yes.
Yes, my lord, order was passed to file affidavit. Now government has not filed any affidavit.
Yes, government. Huh? Why Manipur is here and not in the Manipur High Court?
No, my lord. It is the vehicle was requisitioned by the district authorities, Kamrup Metro, my lord, and this was handed over to Manipur, my lord, for use of it for election things, my lord.
Okay, anyway. Affidavit, no, you get your instructions. What are you asking for?
I wanted for the money, the matter, the vehicle was, that is,
Have you got back the vehicle?
no, my lord, it was met of the accident, my lord, during the requisition period.
Pay compensation for requisition.
Oh, my lord. And requisition
Okay.
compensation has also not paid. So where to the accident, my lord? In the
Okay.
requisition period.
Affidavit has to be filed. Okay. Huh? Not subside. Is it the same now?
No, my lord, it's not the same.
Is the Manipur High Court function?
Yes.
Are the lawyers going?
I bow down, my lord.
Then
I
don't
apologize.
make this type of excuses.
My lord, what is flown from
The learned counsel appearing on behalf. What's your name?
of A. Gautam.
A. Gautam, the Mr. Learned counsel appearing on behalf of the respondent.
8, 9, and 10.
8, 9, and 11, as well as government, as well as the respondent in the state for the state of Assam, seeks for an accommodation of 4 weeks for filing their reply to list the matter again on 13th of March 2024. The affidavit to be filed by 4th of March 2024. Okay. Yes.
Item number 2, my lord, is such an order. But I have made a contact with my client. Petition has become infractive. Because term of the panchayat, my lord, already offered.
Very well.
Lord, I have, my lord, made a contact my client. So he said that term of the
Item number
my lord,
2,
panchayat
item number 222 order to liquidate. Mr. A.K. Purkasth, the learned counsel appearing on behalf of the petitioner submit that the petition has become infructuous in view of the fact that the period of the panchayat,
expired.
period of Gram Panchayat
The panchayat.
had already expired. And as such, he has instructions not to press the instant petition. Taking into account above, the instant petition stands dismissed on as it had become infructuous.
My lord, I'm extremely sorry.
But Mr. Purkasth, the thing is, no, not only for you. I have to appreciate everybody I have given this 5,000 as cost. Now, if I hold you not and others, then it will show that this court has been unfair to the juniors, but has been more fair to a senior counsel, which this court would not like to.
I'm sorry.
Well, here I pay for some type of highlight. On the last occasion, the finance has been implemented.
What is this matter about?
Regarding payment of
Okay. Yes, this is a very important matter. Huh? Yeah.
After 3 weeks.
Mr. B. Gogoi, the learned counsel appearing on behalf of the Finance and Taxation Department, submits that he would like another 4 weeks' time for filing the reply. Taking into account above, this the matter again on 23rd of February 2024. The affidavit be filed by 19th of February. On or back. 50. Yes, why the matter is so big and thick matter?
Well, this
What is this IA for?
for restoration of the writ petition, which has been dismissed on the last occasion on 1912 and for the respondent railways.
Econ order to killing. The record reveals that the petitioner is not represented on the earlier occasion. The applicant is not represented on the earlier occasion. And today also, the applicant is not represented. It was made clear by the order dated 19/12/2023 that if the applicant is not represented, the instant application shall be dismissed for non-prosecution. Taking into account the above, the instant application, taking into account as the applicant is not represented, the instant application stands dismissed for non-prosecution.
Well, I'm representing the railway.
But,
Yes.
this may be taken up next week.
Why? Submit the two and may be filed for you. What is this?
This is
I for what?
for impleting the party disputed.
So then? I will inform the other side.
But one of the colleague, not
Okay. Mr. So-and-so, the learned counsel appearing on behalf of The applicant, at the request of the learned counsel for the applicant, matter stands adjourned to be listed after 3 weeks. Your matter is 23.
23.
23 to dismiss for default no koribo. You have to file. What was the matter about?
This is regarding a settlement allotment of the particular plot of land.
Then?
Then, my lord, we are possessing the land, but the state has been, my lord, allotted to the, my lord, Zilla Parishad for construction of godown.
Then? What right do you have?
Since we are, my lord, residing there by dwelling houses since last 50, 60 years. So there is an, my lord, interim order passed by the Noble Court. By virtue of the interim order, we are still holding the.
To list the matter again on 5th of February at the request of the learned counsel for the petition.
Development.
It's it.